Welcome to another installment of Employee Termination Tips. My name is Christopher Neufeld of Neufeld Legal, and in this particular video, we'll be discussing the importance of contacting a lawyer immediately after being fired from your job. Now, I cannot understate the importance of avoiding procrastination and delay in this process, given the fact that in the few days that you're provided between the time that you're fired from your job and the time that your employer expects you to accept their termination and severance pay package, they are at their most vulnerable state. And you, as a fired employee, are at your most advantageous state in the whole future process. And that is because during that period, your former employer is anticipating that you will accept their termination and severance pay package. And as such, they are more apt to provide you with information and documents that you might request during this period than at any time afterwards. Because as soon as you reject their proposal or you request an extension in their proposal to reply, you set off alarm bells and the walls go up and they start to refuse to provide information subject to litigation being initiated. That is the reality of how people operate. But in those first few days, they will provide information and documents because they believe you're going to try to get across the finish line. And they have the capacity, without engaging with the lawyers, to bring you across the finish line and get you closed out. And that's how they operate, and that's how human nature is. Now, from the lawyer's perspective and from the strategic perspective, if you gauge the appropriate lawyer in these matters, what they're going to do is take advantage of this time period to not only request information and documents and request that through yourself as the employee, as opposed to requesting it as a lawyer. Two different things and two different responses that you'll receive back from your former employer. But equally important, they'll put in requests that are based off of the Employment Standards Code that oftentimes are rejected or refuted by the employer because they fail to comprehend their obligations to their former employees. And even their legal counsel, internal legal counsel, and external legal counsel will stop them from providing that information. And in so doing, you not only see where the basis for a legitimate case might exist, but you have the means to challenge them afterwards in court with respect to the refusal to provide information and materials that are specifically required by the relevant employment standards legislation. This is very important to the whole process moving forward. You want to be building a case forward should you go forward. Now, on the converse side, if the employer is willing to be transparent, to provide you with all the information you request, then your lawyer can make an honest and more complete assessment of your situation and can provide you with clear information and clear details as to whether or not the particular termination and severance pay package actually meets the legal requisites or comes close to it. The fact of the matter is, most employers still lowball with respect to what they're providing in the way of packages. And that is a reality of the world. But if you're getting somewhat close, it might not be worthwhile to pursue legal action. On the flip side, if what you're getting is less than what is standard and you're getting a lot of rejection and pushback in the first few days by the employer, Typically, that means there is something more that needs to be investigated and assessed, and demand letters are the next step to assert that there should be more coming forward. Naturally, when a demand letter is put out there, it sets off alarm bells and it shuts down the entire process with respect to yourself working with the employer. Now it's lawyer versus lawyer, and that has its own problems. But if you've been able to collect appropriate information in advance, you are in a very good position to have a proper assessment, to make a proper determination moving forward. And this can only be achieved if you've given the lawyer sufficient time to strategize, plan, and then implement that plan so as to collect all the information materials that are possible within the first few days of being fired. Thank you.